My name is Stephanie Rapp-Tully, and I am a partner in the DC office and with the federal employment practice. I practice before U.S. district courts, the appeals courts, particularly in DC and Maryland, but can practice in all districts, particularly when it pertains to federal law, the EEOC, and the Merit Systems Protection Board. So what we're going to cover today is when you need to file informal EEO complaint, if you're going to file one, what to expect when filing informal complaint, how to initiate contact with an EEO counselor, whether to engage in mediation or ADR and what those terms mean, what to expect when you file a formal complaint and the differences between an informal and a formal, and then when to engage an attorney during the EEO process. So before you file, it is important for you to to understand your bases. Why are you filing it? Why is this a discrimination case as opposed to I don't like the way my supervisor is treated, but why is it discrimination? What protected bases are you alleging is what you believe to be the reason for the action, the agency's action? So is it because of race, sex, age, disability, retaliation for prior EEO activity, color, religion? Is it one of those things? And can you articulate why you think it's one of those bases or multiple of those bases? That is important. You need to have that ironed out in your understanding when you go to the EEO office, because otherwise you won't be able to explain it to the EEO counselor when they ask you those questions. There is a substantial difference between discrimination on those protected bases that I listed, and if I forgot one, I forgot one, but those protected bases, and what we call an EEO jerk, which is an equal opportunity jerk. It is perfectly legal for a supervisor to be a jerk, to not like you, to not want to work with you, to not want to communicate with you, if it is because of a personality issue or they just don't like you. That is not illegal. That is not something that you can file an EEO complaint. It is illegal and in the statute, and you could file an EEO complaint if you believe it is because of one of those protected bases. So you need to familiarize yourself with those bases, be able to explain why you think it is. Now, it doesn't have to be concrete like the supervisor says, I'm doing this because of your race. It doesn't have to be like that, but you need to really be able to articulate why you think it is because of one of the protected bases. And that is critical that you do before you start filing with the EEO office. So you need to have a general understanding of the process in your agency. All agencies are different, but generally you have to contact an EEO counselor in the EEO office and file an informal complaint. Now, a lot of EEO offices call it an inquiry or an intake. So long as you're making contact, that stops the clock, which I'll talk about in a second, and is initiating contact. When I said the clock, you have 45 days from the date of an event, something that happened, to initiate contact with an EEO office. That isn't 46 days. That isn't 47 days. It is 45 days. There's an exception when it comes to a hostile work environment, but you always must have at least one of those events be within the past 45 days. So if you are on day 46, you're not going to go very far in the process. So it needs to be within that time frame. And you need to initiate contact. You don't have to have a formal complaint filed. You don't have to have all your information submitted. You have to initiate contact and be able to prove that you initiated contact. Then you need to choose between conflict what type of counseling you're going to have. There's traditional counseling, which means that the EEO counselor goes, takes your complaint, here's what you want in resolution, and then goes to the management officials designated, sees if it can be resolved, and then comes back. The alternative is something called alternative dispute resolution, ADR, which is also can be referred to as a mediation. In later stages, it's a settlement conference. It's a process by which you discuss resolution. And that is a more, it's informal in a sense, but it's a more formal set, and then you're all in one location. You are discussing what you want in resolution with the designated management official. The agency can designate whomever for that ADR, and there's a mediator that goes back and forth. But you need to be able to pick which one you want because it does have different timing requirements for the EEO office. So when you frame your claims, you need to describe the discriminatory act in detail, but you need to say what it was. What is the action that the agency took against you? And you need to, again, be able to explain why you believe that is discrimination. And this is a running theme, but you need to understand your bases. Why is it disability discrimination? Why is it gender discrimination? Why is it age discrimination? And you need to keep that 45-day deadline in your mind because, like I said, it's a very hard deadline. If you're at day 46, you're untimely, it's gone. So after you initiate contact, the EEO counselor will reach out to you to meet with you. Initially, it'll be to go over what you've said your claims are, to kind of parse those out, describe them better. It is an interview in the sense of they ask you questions. Keep in mind that while the EEO counselor is a neutral, they do not represent you. They are not going to make your claims for you. They also are not supposed to represent the agency, but they also work for but they're not supposed to represent the management. It is supposed to be a neutral, but keep in mind that they are not representing you. The EEO counselor then is the go-between between you and management. And when you do the traditional counseling, that is a 30-day period. The EEO counselor has 30 days to go between the complainant and the and management to see if the complaint can resolve. They usually will say, hey, this person is discussing or is alleging blah, blah, blah. Does management have a response? And they capture their reflection of the management's response in what will later be produced as the counselor's report if you move forward in a formal complaint. But it's their notes. It's not an actual statement from the management official themselves. EEO counselors do not have the authority to make any findings. They cannot speak on whether a claim holds legal weight. They can give you, I mean, if you're late, they can tell you that. If you say, I think it's because of age and you really have nothing there, they could say, I'm not seeing a lot, but they can't, they don't have the authority to make those determinations. They are not judges. They are not agency counsel. They are EEO counselors and are supposed to be the mediators or the go-betweens in processing the complaint and discussing resolution. If you participate in ADR that extends the informal complaint process to 90 days, then the EEO office has 90 days to get a mediation scheduled and conduct that ADR session. That is the most common form of ADR. Most of the time, those terms are used interchangeably, mediation and ADR. And most of the time, that means either through, nowadays, it's a lot of virtual, but sitting in a room, either virtually or physically, and going, discussing claims, discussing events, and discussing resolution. Through either process, if the dispute is not resolved during the time frame and during the counseling, then the EEO counselor in the EEO office will issue a notice of right to file a formal complaint, taking you to the formal complaint stage. Once you receive that notice of right to file a formal complaint, you have 15 days from receiving the notice to file your formal complaint. Not 16, not 17, it is 15. You need to make sure you guard that deadline because it is a hard deadline. And if you're late, it is very hard to bring it back. So you need to make sure that you get your formal complaint in within that 15-day time frame. Unless you are amending your complaint to include something new that has happened since the initiation of your informal complaint, you are to include the claims that you alleged in the informal complaint stage. You can't go back and try to add things in later that are not new. You can add a basis at any time. So if you think now based on something that was said, it's now a different basis or you add a basis to it, you can do that. You can amend bases at any time, but claims you cannot, events you cannot. And that is because the informal complaint stage is also to provide notice to the employer of what is being alleged. The agency, once you file it, the agency will send an acknowledgement confirming receipt of the complaint. And then it'll say that it is going to review the complaint and decide whether to accept, dismiss either all or part of your complaint. Going back to the acceptance letter for a second. So the agency, after it decides whether it's going to accept your claims in part or dismiss part of them or dismiss everything, either because of timeliness or failure to state a claim. In other words, the agency does not believe that it holds water in the law. You do get the opportunity to, if it's dismissed in part or if the agency mischaracterizes claims, you can object to that. That will be included in the letter, the timing and the ability to do that. If the agency dismisses your entire formal EEO complaint, you will have appeal rights. But if only part of it is dismissed, you don't have immediate appeal rights. So once the agency has determined if that the claims have been accepted to move forward to investigation, it will then delegate authority to an investigator, sometimes outside of the agency, to investigate the claims. Once the investigator contacts you, they will advise you that they intend to interview you or send you a list of questions that it wants you to respond to. So they will either ask you questions and write down your answers for your review, or they will send you a list of questions, you fill it out, send back the responses to the investigator, and then that gets included in the report of investigation that's produced at the end. The investigator is not a decision maker. They are there to collect evidence. Frankly, even if they did include their thoughts and opinions on the evidence, what has been produced, what has been said, that's not evidence. Not at all. The characterizations of what is included in the ROI are not evidence before a judge. The report of investigation is a compilation of evidence. That's really what it is. It has no conclusions, it has no findings, it is a compilation of evidence. Eventually, that is produced. By statute, the agency has 180 days from the filing of the formal complaint. Now, that's the filing, not the acceptance or the acknowledgement. It is the filing to investigate the claim. If you amend your complaint at any time, that 180 days gets bumped to 180 days after the amendment. However, it can never go beyond 360 days from the date of your formal complaint filing. So at some point, you will be issued a report of investigation, and it will come with a notice, an advisement of rights. And that advisement of rights will say that within 30 days of receipt of the report of investigation and this notice, you must decide if you are going to request a hearing before the EEOC and an administrative judge at the EEOC, or you're going to request a final agency decision, or you can do nothing. The final agency decision is basically, hey, agency, review all the evidence. Did you discriminate against me? You can guess where the majority of those decisions end up. The hearing request is so that you can appear before an administrative judge and have your case determined by an administrative judge. Now, you can elect a hearing request and change your mind and then request a final agency decision, but you cannot do the inverse. You cannot elect to do a final agency decision and then change your mind and go to the EEOC. So 30 days, you must make that determination and submit either a hearing request to both the agency and the EEOC or a request for a final agency decision to the agency. And again, that's 30 days, not 31, not 32, 30. It's a hard deadline. The agency's 180-day, not as hard of a deadline. I know. You have to, it's important, and the notice should include this, but you need to make sure you include the EEOC office that would adjudicate your claims, and it's geographically based. So whichever is geographically closest to where you work is the office that you should include. That doesn't mean that's the office you'll end up at. Sometimes EEOC offices swap cases or pass cases based on case loads, but that is where you need to file. The EEOC hearing adjudication process is similar to a federal court process in that you can request discovery in the process and work through the case. It's a trial court level type of adjudication. So you would get discovery, there are dispositive motions, and if you get through those, then you have a hearing on the merits to be decided by an administrative judge. Agency attorneys are not supposed to be involved in the informal or the formal complaint process other than if they attend a mediation or in the review of the acceptance letter. They are not otherwise supposed to be involved in the adjudication of the case. However, you file a hearing request, agency counsel then becomes involved and will likely represent the agency, the defendant in the matter, against you. Assuming you get through the process and dispositive motions, at some point, an administrative judge will conduct a hearing, make a decision, and then order relief based on that decision. I want to spend a minute talking about the process just to make sure it's clear. So you file your hearing request, you're going to get an acknowledgement from the EEOC, and at some point an initial conference order will be issued. That at that call, it is not your hearing. This is when you talk about the processing of the claims. The judge reviews the claims and whether discovery will be allowed. Discovery is your opportunity to ask the agency for additional information that was not included in the report of investigation that is related to or would lead to relevant information pertaining to the claims. You can also have the opportunity to take depositions during that process. Those timelines will be set up, and then the deadline for usually the agency to file what's called a motion for summary judgment, which is a dispositive motion, basically saying that the case should be dismissed, is set up, and your opposition thereto, you need to meet those deadlines or make sure you communicate well in advance if you need an extension. The judge will then issue a decision on that motion and either decide that they're granting summary judgment, i.e. your case has now been dismissed and you have appeal rights, or we are moving forward to a hearing. The judge will then schedule a hearing, will preside over the pre-hearing submissions, which is what are your witnesses, what are your exhibits, and then hold the hearing where you will have the opportunity to testify and call witnesses, as will the agency. The agency will also be able to designate witnesses, be able to cross-examine the complainant, and present its arguments. The judge will then issue a decision. So you get a decision from a judge either on a dispositive motion or after a hearing. Depending on what the decision is, the losing party, and actually it could be a partial decision. So either party has a right to an appeal so after you get a decision, the agency has 40 days thereafter to either adopt the decision in whole or issue its own decision. Most of the time, particularly if it's in the agency's favor, they adopt the judge's decision in its entirety. They have 40 days to do that. After the agency issues its final agency decision, then there is 30 days to appeal that decision. You must file the notice of appeal with the Office of Federal Operations, which is the appellate branch of the EEOC. It's just a notice, the form is on the website, but then after that, 30 days after, you have to submit a written brief as to why the judge's decision, the agency's decision lacks legal sufficiency. There were issues with what happened during the hearing or during the case processing, and why the case should, the decision should be overturned. That then goes to the Office of Federal Operations, where they review the record. When the record is everything that is on the EEOC portal, all the documents submitted by the parties, and make a decision. That can take a while. All of this can take a while, but that can take a while. They will then eventually issue a decision. It says their appellate process often takes more than a year. Definitely. It's more than a year. It is a very slow process. When can you file a lawsuit? Very good question. Some people want to jump straight to it. You can't do that. You must go through the informal and formal complaint process before you can file a lawsuit. Must. It is when you get that advisement of rights that you can go down the path to take you to court. So if that is what you wanted to do, when you get that advisement of rights, you would request a final agency decision. Once you get the final agency decision, you have 90 days to file in court. 90, not 91, not 92, 90. 90 days to file from the date you receive that final agency decision. If at any time you receive a final agency decision, you have 90 days. So if there's a final agency decision adopting a judge's decision or incorporating a judge's decision, 90 days. Your clock does not start running until you receive the final agency decision. However, you must allow at least 40 days for the agency to issue the final agency decision. If, however, you file an OFO appeal, you have to allow OFO 180 days before you can go to federal court. So you have to allow the OFO to process the appeal, issue a decision by at least 180 days. You can't file an appeal. It creates a headache. If you file an appeal and then try to withdraw and go to federal court, you have to allow the 180 days. But again, once you get that decision from OFO, you have 90 days to file with court. And you would, if you're a federal employee, you would be filing in a U.S. district court where you work typically, where the actions occurred, where the agency is. So you need to understand what court specifically you're filing in because it's based on jurisdiction. If you're in Washington, D.C., most likely you'd be in the U.S. District Court of Washington, D.C. If you are in Greenbelt, you would be in the U.S. District Court of Maryland, etc. So when should you engage an attorney through that entire process? The EEO process is a very, very long and complicated process. And you heard me mention a whole bunch of deadlines that you have to guard because complainants are held to a very strict standard on deadlines, not as strict on agency, and there are no deadlines, at least outward-facing, public-facing deadlines for EEOC judges, federal court judges for that matter. There are no deadlines. So complainants are held to a much stricter standard in terms of deadlines, when to file, and it is your burden. In all Title VII EEOC cases, complainant bears the burden, the initial burden, and then it's kind of a shifting standard, but you bear the initial burden. So it can be a very complicated, very high stress, intense situation. A lot of things run very fast. There's also a lot of times where it's hurry up and wait. So you do a lot of things very fast and you got to work through things and then you don't do anything for a year while you wait for a judge's decision. It can be a lot. You're already going through a lot if you're facing discrimination. And so having an attorney to guard those deadlines, make sure everything's being filed on time and correctly, and the best format of your claims as it can be, takes that stress, that burden off of you. And I hear a lot of clients tell me that alone is worth its weight in gold. Having that support, having that person on your team, not having to do those things yourself. Consulting an attorney when formulating your claims could radically change how your claims are processed. If you misstate your claims or leave something out, like I said, events, if you don't include it within the 45 days, it's gone. So if you don't include that at the beginning, that radically changes what your claims might be down the road. How you frame your claims matters, how you pursue them. So even though the earlier stages might be administratively easier, these are things that you need to have consideration of ahead of time and understanding that process. Mistakes, inadvertent misunderstandings can happen at any time. Told you there are conversations where you have with an EEO counselor and an EEO investigator. If they misunderstand, misstate your claims, and you don't address it at that time, you may have lost the ability to address it. And that can cause problems down the road in adjudicating your claims. So it's best to consult an attorney to make sure that all of your claims are properly and accurately stated and that everything is submitted on time and in its proper format. That's Tully Rinckey, that's what we do. That's part of what we do. We can assist in everything I've mentioned in terms of the process, the informal complaint, the formal complaint, interviews with the EEO counselor, investigative interviews, filing a hearing request, going before an EEOC judge, going before the Office of Federal Operations, the OFO. All of those things are things that we can do. We can also go to district courts. Again, it will matter the jurisdiction, but we can also do that as well. These are all things that we can represent in mediations. So these are all things that we can assist you with. Brittany, I want to get to some questions. I want to say before I get to some questions, so if you have a question that is specific to your situation, I can't answer that here. I can answer general questions about your process. But if you want to ask about your situation, it is best to contact us for a consultation so that we can go over specifically your situation, what is going on, how we can address your needs, and what the best steps are for you. General questions about the process, things I've talked about, I can absolutely go over. So let's say you decide to book a consultation because you want to talk about your specific events, like I just said, because I can't answer questions about those here. What you should do to prepare for your consultation. It is a good idea to be able to describe the things that are listed in this list. What took place, when it took place, how often it took place, who initiated it, who was involved, the position of that person, your position, relation to that person. Were there any witnesses? Were there any ancillary comments or things that occurred right before that, right after that? Those types of things. A timeline is something I'm going to ask you for once you retain, once I find out you're my client, and I'm going to immediately ask you for a timeline, chronological order of events. So if you have those things in your mind, at least written or jotted down, you're taking a good step. The other thing is to have any important documents with you. So if you were suspended for 5 days, have that notice of suspension, decision of suspension, having those things. I'm seeing questions pop up, but they're not sticking around for long. So hold on, let me see if I can get to them. There it is. I want to turn over. Someone asked about contacting an EEO counselor. I'm sure if you're a federal employee, you know that many federal employees aren't there anymore. And that's happening a lot in the EEO offices, as we are seeing in various agencies. It may be the case that someone who is identified as an EEO counselor is not there. So how do you do that? You need to, most agencies have an intranet site, an internal site that should include the EEO office, general EEO contact. Keep reaching out, make telephone calls, find someone at the EEO office to initiate. Email, because if you email, you are initiating contact, and you can prove, so long as you keep the email and it doesn't go anywhere, you can prove that you did that. So that's how I would handle that. But don't let it sit. How soon is a hearing scheduled after one is requested? Very good question. I told you this process takes a long time, and I wasn't kidding. It can take a very long time. So if the judge allows for written discovery, typically a written discovery period is somewhere between 60 to 90 days. But then a briefing schedule, like I said, is scheduled. That's usually 15 days after the close of discovery, the agency files its motion, 15 days thereafter you file your opposition, and then it goes to the judge for decision. That does not have a deadline. So that could be a couple weeks, couple months, longer. So it could be well over a year from the time that you file your hearing request to when you actually would appear at a hearing before a judge. Does the hearing process continue at the EEOC Commission if the complainant is no longer a federal employee? Great question. Yes, it doesn't go away. So if you are terminated, you retire, you can still, you retain your right to your EEO complaint. It does not go away. You should not make employment decisions strictly based on the fact that you need to be a federal employee to continue your EEO litigation. You can retire, you can resign, all those things. So that moves forward. Someone asked if I have experience with discrimination complaints based on age and disability. All of them, all of the bases. Yes, that's what we do. Someone asked about if you are named as the responsible management official. That's a great question. That's another side of this. So let's say you find out that someone says that you discriminated against them, and they file an EEO complaint. Typically, you'd be contacted for it and to provide a statement. All litigation, EEO, particularly EEOC Title VII litigation, is against the agency, not against any individual person. You cannot go after an individual person directly in their personal capacity. It is against the agency, and actually, it's usually the head of the agency, the secretary, the administrator, etc. But you would be, if you're the responsible management official, if you're named in it, you would have to provide information. You would likely be asked an affidavit, a declaration, and then you probably won't hear anything for a while until whether you're going to be needed for written discovery, depositions, or a hearing. You are entitled to have, you can have counsel to look over your declaration. If you're at the hearing stage and you're appearing for a deposition or for a hearing, the agency is representing the agency, so they would be acting on your behalf, but you can have your own counsel as well to represent your interests. Someone asked about an MSPB appeal. So that's a completely separate venue than what I've been talking about. I've only been handling EEOC cases. MSPB appeals are another way that a federal employee can challenge employment actions. The big breakdown is if you have an adverse action up to that is 14 days or less, that can go to the EEOC. If it is more than 14 days, that would go or something else, a demotion, a termination, that usually would go to the MSPB. There are exemptions if you're a probationary employee, et cetera, but then you would go to the MSPB. Talking about the MSPB process is a webinar in and of its own, but it is a relatively similar process minus the dispositive motions. You would be asking for a hearing before an MSPB judge. So someone's asking, because I mentioned that there's no set time frame or end date, could an appeal be put off indefinitely? No, that's not how the EEOC is supposed to operate. From my understanding, there are internal deadlines that the commission likes to uphold for judges, but they are not statutory deadlines for judges to issue decisions. Courts don't typically have that, and the EEOC does not have that. But that doesn't mean there aren't guidelines and performance standards for EEOC judges or the Office of Federal Operations and the attorneys that work there. So there are standards that that the EEOC likes to hold in terms of timeline. It's unusual for it to be held. I haven't had a case that's been held indefinitely. I would do some following up if it's been more than a year and a half, 2 years. Sometimes things are misfiled, misplaced, and you just need to follow up. But indefinitely is not likely. Can't say it's impossible, but it's not likely. Someone asked about if the EEO counselor wants to change your claims. They are your claims to make. They are your claims to make. And maybe that's a time when you need to consult with an attorney, because remember, an EEO counselor is not a judge. They cannot make determinations. They cannot tell you what you can and cannot do in terms of what claims to bring. Now, if it's untimely, that's a different, they might be just giving you advice, but in terms of that was 3 years ago, you can't bring that now. But if it's what bases you should allege, that really doesn't seem discriminatory to me. That doesn't matter. It doesn't matter. It's not evidence. It's not a determination. And perhaps you need to consult with an attorney to make sure that you are getting your claims accurately put across and established in your complaint. So the question is, does the EEO continue after a complainant retires? Yes. Is terminated? Yes. It all continues after initiating contact. So what is the implication if a complainant is no longer a federal employee? For one, if you're no longer a federal employee, you don't have access anymore to your email box, right? You're not a federal employee, you don't have access. You don't have access to documents. So you lose the opportunity to have quick access to those things, and you're going to rely on the agency to produce those at some point, either through the report of investigation or in written discovery. So that is a big thing to think about. But other than that, again, it shouldn't have a fundamental difference. It also can change your damages. So if when you start the EEO process, you want something like a reassignment, you want a different supervisor, you want your hours changed, you want different duties, whatever it is, all things that relate to you actually performing the job, and then you're no longer an employee. Obviously, those things are not going to be damages you'll want to seek because you're not there anymore. Why do you care what your duties are if you're not employed? So your damages may change. What you're seeking may change. And how you approach from a strategy position because of that may change. Will an administrative judge consider verbally a CFR regulation in a hearing? A hearing is designed to first elicit evidence. So you're eliciting testimony, presenting evidence, factual evidence to support your claims. And then at the end, like most trials, most hearings, you make arguments, which will include legal arguments. So if you present a legal argument in your closing, you're able to do that typically. Some judges do prefer written closings and not verbal closings, but that is a judge preference and can be discussed at a conference. Someone asked about a FOIA request during the discovery process. You can make a FOIA request whenever, but the discovery process allows you a little bit quicker access. FOIA requests can take quite a long time to process, particularly now, and the discovery process is much faster. So, you can file a FOIA request, but if you submit discovery requests, assuming that they're accurately tailored and narrow so that they relate to your claims and the agency can respond to them, it's going to be much faster to get the information through there. Someone asked, because I've mentioned it quite a few times, what happens if you miss a deadline? It's hard. If you miss a deadline and the case is dismissed, you can appeal it, but it's a hard one to come back from, and it does depend on the deadline. So a deadline to submit an affidavit to the investigator, not as hard of a deadline. You can ask for extensions on those. Those are not what I call, they're not dispositive deadlines to miss, but there are some deadlines that if you miss them, it's gone. And those were the ones that I highlighted, but that is the 45-day deadline, the 30-day formal complaint deadline, the 15-day hearing request deadline, and then that 90-day filing court deadline. Those ones are hard. And unless if for whatever reason there are circumstances that are extreme circumstances that have caused you to miss the deadline, you can make that appeal, but it is a very high standard and very hard to do. And I would definitely consult an attorney at that point. Someone asked about recording a conversation with you and management. Oof. There are a couple of things you should do. You should look over your agency's policies on that, because that can have disciplinary action. And you should look over your state laws and where people are located in states. Definitely be aware before you do that. Certainly before you admit doing that. That is another thing that the firm can assist with as an adverse action. So if you do have a suspension that has been noticed against you, we can assist with drafting a response for all disciplinary actions, except for maybe a letter of reprimand, accounts, things like that. But for all suspensions, removals, you have the opportunity to respond to the notice and present evidence or make arguments as to why what they say happened didn't happen and why the penalty is too severe. It should be something else. We can assist with that written reply, an oral reply. And then if there is an appeal after a decision has been made, we can assist with the appeal either to the board or EEOC, or we could incorporate that into an existing EEOC complaint that you have. Someone asked about a deadline to conduct an investigation. Like I said, the statute has 180 days for the agency to conduct an investigation. That is not necessarily a hard deadline. They do have to give you notice that the 180 days has lapsed. They need additional time. If you agree to an extension, you're agreeing to an extension. But if they are untimely, you could seek sanctions. You could try, but it is not as hard of a deadline as the complainant's 30-day deadline, 90-day deadlines, 15-day deadlines. So it's a guideline that they should follow. Sometimes if it's really, really delayed, sanctions will be issued. I believe there's, oh, someone did ask, and this is a good point to bring, do you recommend ADR versus going to hearing? I don't think that's the decision one would make. So ADR is whether or not you resolve the complaint then, whatever's happening then. At the informal complaint stage, settlement can happen anywhere, at any point in the process. So I always think of it as two concurrent paths that are going down. Pursuing settlement doesn't mean you're not pursuing your case until you have actually resolved. So I wouldn't say it's an either or. You can do that at any time. It does take two to tango, so you have to have both parties willing and interested to engage in those discussions, but they can happen at any time. Someone did ask about a discovery request and how prior to a hearing, is this something that someone's attorney should? So you have to see what the judge is allowed. An EEOC judge, well, and a court judge too, can determine what discovery is allowable and what is not. Sometimes an EEOC judge thinks that the ROI is sufficient and can go right to dispositive motions or right to a hearing. They can make that determination. So it really is dependent on what is decided by the judge as to what's allowed in discovery. But if a discovery schedule is set out, typically what happens is the judge will say each party is allowed a certain number of requests that you can make to each other. You have a certain amount of days to initiate and then a certain amount of days to respond to each other's requests. And if you think that there's information that's not in the ROI that is relevant or important to your claims, you should probably ask for it. And yes, that's something an attorney can, and that would be very helpful to have an attorney do because they can be very intricate, particularly since you're now dealing with an agency attorney on the other side. I think this is a good point. If you have any additional questions, you can always reach out to us. You can always contact us to schedule a consultation. There's the telephone number at the bottom, and you can email to ask for a consultation. We have plenty of attorneys ready to meet with you. It's not necessarily going to be me, but you have plenty of attorneys that can meet with you and discuss your situation and see how we can assist you in the future. I thank you for your time today and hope everyone has a great weekend. Thank you.